Good evening and welcome to tonight's edition of Fact Sheet live on ETV, live on NISIM 95.9 and 100.1 live on Facebook, Twitter, and Instagram. Our handle is ETV Ghana. You're welcome to tonight's conversation. There is a phrase, there is a sentence that you'd have heard before. Virtually every radio station you would have tuned in, every TV station you would have watched, or maybe passing comments from some of your friends who may be lawyers. You'd have heard it before. Fundamental human rights of a Ghanaian. Fundamental human rights of a citizen. I'm sure you've heard it before. But what really it means, how it applies to your day-to-day activities in your life, have you considered it? The 1992 Constitution guarantees the fundamental human rights of a citizen of this country. If you read Chapter 5 of our Constitution, it's clearly spelled out there. But what goes into the fundamental human rights of a citizen in this country? Tonight, that's what we want to discuss and have a conversation about as to your rights as a citizen in this country. Let me give you a sense of what we are going to be discussing this evening. Now, did you know that a person who is arrested, restricted, or detained shall be informed immediately in a language that he understands of the reasons for which his arrest has been made, or restriction, or detention, and of his right to a lawyer of his choice? Did you know that? It goes on to tell you that upon reasonable suspicion of his having committed or being about to commit a crime, commit a criminal offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest. These are rights that are guaranteed you, and yet maybe you might not know about it. Maybe you might know about it, but you'd have been to a police station where these rights have not been read to you, or you knew about them, or you didn't know about them, but they were infringed upon. If there were, what remedies are there per the Constitution's position when it comes to these issues? And so tonight, we'll try to make sense of what these fundamental human rights are enshrined in the Constitution and how we can utilize them when we find ourselves in positions where we would need to stamp our feet and demand that our fundamental human rights are respected in this country. That's our focus tonight on Fact Sheet, where we speak to the facts and nothing but the facts. My name is Samuel Shen, and I'm happy that you made time to join us tonight on Fact Sheet. We'll just turn around, and when we are back, I'll introduce you to my guest, and then we'll start a conversation. Do kindly stay with us. And welcome back to Fact Sheet live on ETV. I am happy that you made it a point to join us. We would encourage you to share the links to your groups and platforms that you are on, be it on WhatsApp, Telegram, Facebook, Instagram, Twitter, any of the social media platforms you may be on. We would encourage you to share the links so others may also follow the conversation to learn a thing or two from what we're going to be discussing. And so tonight we're talking about the law, your rights, and what you should know. And my guest is lawyer Godfred Eniminyako, who is an associate with Yalberima and Co. Afisem Chambers and member of Crime Check Foundation to try and make sense of what the Constitution means when it talks about our fundamental human rights and its preservation. At what point do we exercise it? At what point does the law also kick in? It's good to have you back in the studio again, Godfrey.
Sammy, it's good to be back. You have a lot to talk about. Yes, yes. And you have to end in the evening.
Yeah, we have to end in the evening. We have to end in the evening. So, in the morning, we tried to make sense of, it was a very restricted area we were in, but I want us to open up the conversation and talk about what our fundamental human rights are. What do we mean when we say fundamental human rights?
Yes. I will start by saying that human rights in general, you will say they are basic rights. That's you are entitled to by the mere fact that you're a human being. So they are universal rights, and they call it inalienable. Okay. That they cannot take it away from you. You are entitled to it because you're a human being. So certain basic rights, like right to life, right to economic well-being, right to health, these are basic human rights that you are entitled to as a human being. So nobody can take from you. The human right that you enjoy in Ghana is the same human right that you enjoy elsewhere, globally. So those are the basic meaning of human rights.
It's interesting you said that what applies here applies elsewhere. Yes. But if you look at what the Constitution says, and let me read a bit of it to our viewers, Chapter 5 And let me start where it talks about the protection of fundamental human rights and freedoms. The fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and agencies, and where applicable to them, by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this constitution. And it speaks of the protection of the right to life, and it says, no person shall be deprived of his life intentionally except in the exercise of the execution of a sentence of a court in respect of a criminal offense under the laws of Ghana of which he has been convicted. A person shall not be held to have deprived another person of his life in contravention of clause 1 of this article if that person dies as a result of the lawful act of war, or if that other person dies as a result of the use of force to such an extent as is reasonably justifiable in the particular circumstances. And it goes on to talk about some of these rights, and it says that every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the following cases and in accordance with procedure permitted by law. What does the Constitution mean when it says personal liberty?
Yes, so you've started reading some of the rights that the Constitution has enshrined. But what the Constitution did was to state at Article 33 that these rights that are enshrined are not exhaustible.
Okay.
Meaning that there's other rights that you're entitled to, but cannot be captured in this single document.
Okay.
So what the Constitution is that, first, you have your right to basic or personal liberty. You have the right to movement, you have the right to go to anywhere you want to, except where there are some restrictions attached to it.
Okay.
You have the right not to be held against your will, not to be falsely imprisoned. So if somebody falsely imprisons you, you have the right to protect yourself. So this personal liberty is there to protect you as a human being. But then, as much as the law gives you rights, the law also gives you some restrictions. Okay. So you can see that the article provides that there are some restrictions that can be imposed by lawful authority of the law. So at a point in time, the police can restrict your personal liberty if you are suspected of having committed an offense. Even you have private persons, citizens arrest.
Yeah.
So if a private person catches somebody in the commission of an offense, the private person can arrest the person and present the person to a police station. So at the point in time, your personal liberty has been restrained, even though you have the basic right to it. So the law has provided restrictions to personal liberty, but the law puts in a caveat. But there must be a lawful restriction. It's not every restriction that is lawful. So if a police arrests you and does not go through the process of arrest properly as outlined, then the arrest becomes unlawful. There are cases that the court has outlined that you can use reasonable force to resist an unlawful arrest. There was a case that the policeman unlawfully arrested somebody. The arrested person overcame the officer and in the process destroyed the uniform of the officer. They attempted to charge the arrested person with other offenses, including resisting lawful arrest. But the court insisted that because the arrest in the first place was unlawful, as a basic human right, you have the right to resist an unlawful arrest. So those things are there. That's why the law has outlined various procedures to go through, various means to go through, and then the way the police should go about a lawful arrest. The first restriction is that the police must tell you the reason for your arrest. If they don't tell the reason for your arrest, it becomes an unlawful arrest. You have the right to use reasonable force to resist it. Secondly, the police must tell you the person who has made the complaint against you. The complainant. If there's a complainant, yes, the police must inform you that this is the complaint that's been made against you. And that this is the charges these are the complaints made against you. These are what you are required to do. The police must inform you of your basic legal rights. Your right to have counsel of your choice. Your right not to self-incriminate yourself. The police must inform you at the point of arrest. The police must also inform you that you have other human rights that you're entitled to as a human being. So those are basic fundamental human rights that you must be informed prior to your arrest.
Now, the point about the police informing you before effecting an arrest.
Yes.
Now, what should these contain? That information, what's contained within that information? Because as I was reading, it speaks about a person who is arrested, restricted, or detained shall be informed immediately in a language that he understands, or the reasons for his arrest, restriction, or detention, and of his right to a lawyer of his choice. What is to be communicated to me at the point of my arrest?
Yes, this is what the Constitution says. But there's a police handbook that they often use
Okay.
that has summarized these basic human rights
Okay.
in the handbook. First, the police must ask you of the language that you understand and can speak comfortably in. So, what the Constitution says that your rights must be read to you in a language that you know and understand. That's the first right. And then they must also inform you of the reasons for the arrest. That's the second right. They must inform you of your right to have a lawyer of your choice. So these are three basic fundamental rights, human rights, that must be read to you at the point of your arrest. Otherwise, the arrest becomes unlawful.
Now, for instance, I'm driving.
Yes.
Policeman stops me. Park. And then I park. Your license.
Yes.
I give my license out. Checks my DVLA insurance. Everything is okay. And then looks at my car and there isn't that, sticker, the red sticker that is there. And then he says that, okay, let's go to the police station. At that point, what processes is to be adhered to for me to know that this is the reason for which I'm being arrested? And at what point do you know that this is a lawful arrest and this is an unlawful arrest?
Okay, so what I would say is that the police, they normally use two main strategies, either to invite you or to arrest you. If they are inviting you, at that point in time, they haven't arrested you. But with the scenario you give, it is an arrest because they have identified that you haven't conformed to road traffic regulations. So they must inform you that we are arresting you because you don't have a roadworthy certificate. We are arresting you because you don't have a valid license. So at the point that they are taking you to the station, they ought to inform you the reason for the arrest. Unless they are just inviting you, you are just a person of interest. That is different. If they are doing a general investigation and then they decide that we don't know who and who had committed the offense, so let's do a general invitation of persons whom you suspect to have committed offense. That is different. That is just an invitation. At that point, they haven't arrested you. So there's no obligation on them to inform you the reason for the arrest. But where they have stopped you and they requested for documents that you couldn't produce, and then they go ahead to invite you to the station, it's an arrest. So they must inform you the reason for the arrest. Otherwise, you can use reasonable force to resist it.
So I am home and somebody calls the police to tell them that, some suspicious characters came into my house the night before.
Yes.
And the person tells the police that because of some armed robbery cases which have been going on in the area, they suspect that the people who are in my home are, gang members and that maybe we might be planning some arrest. In that respect, if the police comes to my door, knocks and says that they want to come in because they have been given this information concerning armed robberies which have been going on in the area, what rights do I have?
No, at that point in time, they are not arresting you in any way. They are just conducting their usual investigation. So if they don't have a search warrant or there's no reasonable suspicion that you have committed an offense, they cannot barge into your house and then do any investigation. You must invite them in if you want to. But then if they have reasonable cause to suspect that you have committed an offense in your home, then they may use that power they have to do an investigation at the point in time. But the scenario you're giving, they are not arresting you. They are merely doing an investigation. They are there to ask questions.
So I have a right to tell them I don't want to grant you entry into my home?
Oh, yes, you have a right. In fact, you have the right to your personal liberty. That right can only be restricted where they are arresting you. If they are not arresting you, they cannot restrict your right to personal liberty. Do you understand me?
Now, the interesting thing is about where the Constitution says that a person who is arrested, restricted, or detained for the purposes of bringing him before a court in execution of an order of a court or upon a reasonable suspicion of his having committed or being about to commit a criminal offense.
Yes.
Now, what is reasonable suspicion?
That is what we normally use as lawyers. Reasonable suspicion is objective. It is not subjective in any way. Let me give a scenario. Maybe there has been suspicion of theft, and then a police officer sees you around 1 a.m. in a suspicious behavior, wearing a hood. The police can, using reasonable suspicion that you may have committed offense, restrict your personal liberty for a while until he gets evidence to hold you on it. So the reasonable suspicion is we use the objective test, not the subjective test.
Okay.
So the objective test of a reasonable human being. What would a reasonable human being at a point in time think? If they suspect that you are having a gun, they may not have seen the gun, but then your demeanor alone should tell them that this person may be having a gun with him, so restrain him and then investigate further. So the Constitution says that where the person has committed an offense, or the police officer has reasonable suspicion the person may commit an offense, or in the process of committing an offense, then the person may restrict your liberty within a short period of time once the person has the evidence to hold you on it. But these are rights that normally the police often abuse it. We all know they often abuse it. They can hold you even without evidence. They'll tell you they have the right to hold you for 48 hours. Yeah. Sometimes somebody will make a complaint at the police station with no evidence to support that complaint. But because of this constitutional provision, they'll tell you that they have the power to hold you 48 hours throughout the period they do the investigation. But in fact, in actual sense, they are wrong. You can't just hold somebody or restrict a person's liberty just because you have reasonable suspicion, which is not objective in any way. There must be something to support it. It is not subjective. As I said, we use the reasonable man's test to hold a person on reasonable suspicion of having committed an offense.
Now, I am arrested, or they've visited my home on suspicion that I have some, let's say, criminals in my home.
Like, let's say, narcotics.
For instance.
Yes.
Now, they knock at my door. I open and I tell them. They give me the reason why they are there.
Yeah.
I tell them, I'm not granting you entry. I'm not speaking to you until my lawyer is present.
Yes.
At that point in time, what can they do, and what would reasonable suspicion mean if they feel that, okay, within that window they have, there's a possibility of the people in the house hiding the drugs we are talking about?
Yeah. So the police will not just walk to your house without having any tip-off or reasonable suspicion. If somebody makes a tip-off or somebody makes a formal complaint that we suspect this person has narcotics in the house, that is reasonable suspicion enough for them to come and do investigation in your house without a court warrant. Do you understand where I'm going from? It's not just, how do I put it? You are in this studio. They can't just walk in and say they're going to do investigation on narcotics. There must be something they have to hold on to. So normally they allow an informant to make a complaint first before they can come in. Otherwise, the arrest will be unlawful in the end. Because without a court order or a court warrant, you cannot just go into somebody's house to do an investigation unless there's a reasonable suspicion of the person having committed an offense. Let's say they come into your house. They have dogs that can detect, using their sense of smell, of narcotics in any way. That is a reasonable suspicion. They come to your house and then they find that...
Do they have a right of entry when they are not holding a warrant from a court?
Yes, when they are not holding a warrant from the court and they have reasonable suspicion of you committing an offense, they have the window to do an investigation at that point in time.
But at that point, it is my private property.
Yes.
And without a warrant, I have a right to tell them until I see a warrant, I'm not allowing you into my home. That thin line of reasonable suspicion, who determines it? At that point, when the police officer feels that he has reasonable suspicion, and I feel that, look, there is no drug in my home, and so I don't allow you into my home. Who determines that at that point?
In fact, I get your confusion. Otherwise, we have a situation where the police will abuse this rights or this privilege they have.
Exactly.
What the law prescribes is that the law requires that before you go into somebody's house, you must have a court warrant or order from the court to go into somebody's house. But in a situation where the situation does not require, the situation will not give you the leeway to go for a court warrant or a court order, then using your reasonable suspicion where the law has provided that being an objective test, you can, in order to prevent crime being committed, use your power as a police officer to investigate and arrest the person. So, in fact, that is the leeway we have. That is the thin line between getting a court order and then using the objective test to enforce the power that you have as a police officer to prevent a crime being committed.
Now, we're trying to make the conversation as real as possible
real, yes,
for our
yes,
viewers so that
yes,
it's not too technical. So, indeed, I am arrested and maybe my driver's license is expired and I haven't renewed it, and police officer says, I'm sitting in your car to go with you to the police station. Has a police officer the right to sit in my car?
No, in fact, that is wrong. What happens is that per the law, an officer from the rank of an inspector upwards should have the right to inspect or take your license if he suspects that your license is a fake license or there's something wrong or the genuineness is in doubt. That rank, it's not just any police officer. A police officer above that rank has the power to, within a short period of time, inspect your license and then check the validity or authenticity of the license. What happens is that the law also requires, the motor traffic offences regulations requires that if you have a driver's license, but for certain situations you've left it in the house or you don't keep it with you, the officer must give you a period of 48 hours where you produce the license at the nearest police station. That law is there. Unfortunately, the police often don't use the law because we don't insist on that right. So what they do is that they rather jump into your car and say that drive to the police station yourself, which is wrong. They must give you a period of 48 hours to produce the license if you have at the nearest police station. The challenge they have is that they are unable to trace the various vehicles. In fact, our database in the country is very poor.
Okay.
So they think that if they let you go, you may not report at the station. But that is not within their right to determine that. The law has made it clear that give the person 48 hours, produce the license if he has it. If he doesn't have it, you have other prosecutorial powers to take the person to court and then use other venues that you have available to you.
Interesting. I'm hoping that you are enjoying the
I hope
conversation.
I'm not being too technical.
No, that's why I'm trying to break it down
Yes,
with
yes,
examples.
yes,
Usually,
yes.
conversations on fact sheet are very technical, but I'm trying to break it down as possible so that we can all make sense of these issues and know our rights and how to handle ourselves on the streets when it comes to the rights that are guaranteed by the Constitution. At what point do you demand the presence of your lawyer? Is it at the point where the incident has happened or at the police station?
It is practically at the police station.
At the police
At
station.
the point where you are being arrested, the police has the mandate to read to you your rights. But at the police station where you are required to write your statement, that is when you have the option or the right to demand for a lawyer.
Okay.
If you think you don't need a lawyer, you can handle yourself, that's fine. But then it is a right that you have, so you have to demand for it. So it's at the station that you demand for your right to have your lawyer represent you before you decide whether or not to write a statement to the police.
Now, there is a provision also in there which speaks to the fact that upon being arrested and getting to the police station, you have a right to call a relative.
Yes.
Now, who gives you that opportunity? With whose phone? Is it your own phone? Especially if, for instance, there is a suspicion that there is some information on your phone and the police would not want you to use your phone because at that point you can delete content from your phone. Whose phone is used? How is that done?
Let me deal with the practicality first.
Okay.
Practically, the police do not seize phones when they do arrest, unless they are arresting you because of content or unlawful something you've done on your phone. That the phone will be a means of evidence. But ordinarily, your phone is not supposed to be taken from you, unless you are being kept in custody at that point in time.
Okay.
At the time that you have your phone with you, you have the right to call any relative or any friend that you think can help you at that point, because you may need somebody to stand surety for you. What often happens is that the police sometimes even go to the extent of making phone calls for accused persons. In fact, I've had several of those experiences. That's because we know our system. If you don't feed yourself in the police custody, you have problems there.
Yeah.
So the police require somebody to bring you food
Okay.
and the basic needs. So you have For the phone, they often don't restrain you from using your phone unless until they are keeping you in custody at that particular point in time. But if they are not keeping you in custody, you have the right to use your phone and call any relative that you want the person to attend to you. If the police also decide to give you bail pending their investigations, then it's very important that you get in touch with the sureties who will come and sign the bail bond for you. In the morning, we spoke extensively about bail, but I'll just give a summary of it as we go on,
Yes,
so that
because
people
that's
know,
where I wanted us to drive the
their
conversation
rights,
to,
yes.
because that's one key thing that people suffer at the police station: the issue of the writing of a statement,
Yeah.
and then the granting of a bail.
Yeah.
Now, in the morning, you're making the point that it is not compulsory for you to write a statement at the police station. Now, give me a bit more education on this, because I have been to the police station where police officer says, okay, they brought you, please write your statement.
Okay.
And I have written a statement before.
So let me start by saying that there are two types of statements when you go to the police station. Before you are charged for court, what you write is what we call caution statement, police caution statement. When you are being charged for court, you write a charge statement. For the police caution statement, it is not obligatory to write a caution statement, because at that point in time, the police, they are still conducting the investigation. At that point in time, they've not decided whether or not to charge you with an offense or not. So there's no obligation on you, the accused person, at that point in time to write a statement. In fact, I told in the morning that I mostly advise my clients not to write any statement to the police, because 100% of the obligations on the police to prove your guilt and to charge you. So I don't need to assist them in any way. If they think I'm guilty, they should send me to court with the evidence they have. I don't need to write a statement for them. The second statement is what we call the charge statement.
Okay.
What often happens is that the charge statement is always very short statement. The police will let you know that at this point in time, you are charging with this offense, maybe defrauding by false pretense, breach of peace. You are charging by this offense. What do you have to say? You can write just normally. I let my clients. I have nothing to say. Just prosecute me for court. It's just a statement. You don't need to write an extensive statement before the police can charge you. In fact, whether you write a statement or not, they have already charged you. So it's just your response to the charges that they are preferring against you. Ordinarily, and in 100% of the cases, they will use the statements in court. Do you get me? They will use the statements in court. Most of the time, the statements are used in court against the accused persons.
Okay.
So I would advise people, don't waste your time. In fact, the police will not be happy with what I'm telling people, because often the statement helps them to conduct their investigation. What happens is that when the complaint is made, they do not have any evidence at that particular point in time. So it's a statement that will guide them as to where and where to investigate. So normally, if you don't write a statement, they're often not happy with you. But then it is the right of an accused person to refuse to write a statement, for the police to do their investigation, whether the accused person helps them or not. So I would reiterate that it is not obligatory on the part of anybody who has been charged or who has been arrested for an offense to write a statement.
You have a right to remain silent. Anything you say will be used against you in court. These are things we see in the movies.
Yes.
Is that what's to be done in our system, or is jurisdiction based?
That is what is done in our system.
That's what's done in our system.
That is the right they are reading to you.
That's interesting.
Yes,
because
so the right they are reading to you.
I have never heard this right ever being read to me, but for what I see in the movies.
You haven't had any issue with the law, I think so. When you have an issue with the law, and at the time you are writing a statement, even before you write the statement, there's a prefix. You write this prefix there, that I have been informed of my rights not to write a statement, or of my right to have a lawyer of my choice, but I have chosen to write a statement. That's the prefix you write before you start
write it.
You write it in your own handwriting.
Interesting.
So in your own handwriting, you tell anybody reading the statement that I was given the option whether to write or not to write the statement, but I've chosen to write a statement before you write in the statement. Again,
in the morning, you're talking about the fact that there should be an independent person who should be there witnessing the writing of this statement.
Let me clarify that.
Okay.
It's not every statement that you are writing that you require an independent witness. when you are making what we call a confession statement.
Okay. Confession.
Confession statement.
Okay.
What distinguishes confession statement from other statements are that in other statements you write what you know about the offense that have been charged with. But in a confession statement, you are expressly admitting that I committed this offense. The challenge is that when you are taken to court, the burden of the police is very slim because you have already admitted to that to that commission of that offense. So what the law requires that because the law doesn't want the police to force confession out of accused persons. We all know what police brutality means. They can force conviction out of you. Write that you are guilty, and then we will minimize the brutality we are giving you or the treatment you are giving you. So then the accused person in that situation decides that I have committed the offense, so I'm writing the statement. So what the law wants to prevent is that they want the judge who will determine the guilt of the accused person to know that at the point that the accused person was admitting to the offense, he was doing it of his own free will and volition. So there must be an independent witness who will attest to the fact that he was there when the accused person was writing the confession statement. In fact, there are cases that I've done personally that we had to throw away confession statement because of the brutality that was meted to the accused person prior to the writing of the statement, although there was an independent witness. So we were able to prove in court that although the accused person wrote this confession statement, he did not write it because he intended to write it, but he wrote it because of the abuse that had been given to him at the point in time.
So if the Constitution stipulates this, why do we have instances where major criminal cases in this country, or maybe civil cases in this country, you have prominent individuals who have been taken to the police station or any of the state security institutions, and then their lawyers in public domain or national media tell Ghanaians that we have not been given access to our client. And this is clearly spelled out in the Constitution. And yet you find that prominent lawyers within your field are in the media space saying that we have not been given access to our clients. Is that not a breach of the fundamental human rights of these individuals arrested?
In fact, it is a breach. That is why the lawyers are complaining. Because if you don't complain, the police go ahead and commit the breaches. These are normal breaches that we see in our everyday life. But then the law is against it. So you see lawyers always complaining that we have not had access to our clients.
But why are enforcers of the law, from all the articles that we read, rather the ones who are breaching the 1992 Constitution? With these accounts we hear from the lawyers.
There's a perception in town that if your lawyer is present with you, your propensity of admitting to an offense is very low. The police wants conviction. They want to enforce the law. So within their own evidence that they have, they think you have committed the offense. So whatever they will do to get conviction, they will go ahead. So if a lawyer will come in and then prevent them from getting this conviction that they want, then it is against what they want. So then they, at every point in time, they want to restrain the service of a lawyer when it comes to these kind of issues. But then lawyers always insist. And then there are cases that we have even gone to court for the court to enforce this personal human rights for a lawyer to be present. Because we also request that whatever statement the accused person may have written, without his lawyer having access to him, should be struck out as unlawfully written away. So these are basic rights that, as we advocate and then we advise the public, they should insist on that. If they don't have lawyers available, they should insist on getting lawyers from the states. Legal aid services are there. So if they don't have lawyers available, they should insist that Legal Aid Commission provide them with service of a lawyer before they write the statement, because otherwise they won't write the statement. It is very important that we know our rights and that we enforce and insist that the police and other law enforcement agencies protect and then do what is right, because they are supposed to be the enforcers of the rights of the individual.
Now, on staying on the abuse of the
yes.
human rights of people, Now, the Constitution says that no person shall, whether or not he is arrested, restricted, or detained, be subjected to torture or other cruel, inhumane, and degrading treatment or punishment. Now, are these not inhumane acts that are perpetrated on people at the police stations or at the national security or any of these security agencies that we constantly hear about? It may not be physical torture in terms of an abuse that you can physically see on the skin of that individual, but emotionally,
Yes,
the person is being tortured.
Yeah. In fact, you're a journalist. You have captured most of these incidents. It's happening. I will not deny the fact that these are happening. But then what we also advocate is that as much as possible, even if you will be inflicted with harm, you must insist on your rights. Because at the end of the day, when you are being prosecuted, it is the statement that you wrote that would be used in court to prosecute you. So there has been, in fact, as it stands now, I'm doing almost 2 or 3 cases in court. Yeah, 2 cases that are currently pending against Ghana Police Service and other, I think 4 or 5 other officers for brutalizing my clients during the process of arrest. So these are remedies are available to individuals when they feel that their rights have been abused in any way, either by the police or by other law enforcement agencies, to go to court by the sense of their lawyers for damages for those inflictions committed against them. The Constitution has expressly provided for these rights. The Commission on Human Rights also, in a way, also protect this right, because when you have an infringement, it's also an avenue that you can go to if you decide not to go to the court, for the Commission to also protect and enforce your rights. These are day-to-day abuses that we see in the system. But to be honest with you, for the past year or 2, I've not been seeing these kind of abuses. Our police are being professional and more professional, I would say. But there were issues that were happening in the past. I don't think they go ahead and abuse individuals now. Unless and until maybe you are resisting arrest, then they have to use reasonable force to restrain you. It doesn't mean that they have to go ahead and then beat you or abuse you in any way.
Well, we'll take a short breather. When we come back, we will sum up our conversation with something which some people have complained about, and that has to do with where the Constitution says that a person who has not been convicted of a criminal offense shall not be treated as a convicted person and shall be kept separately from convicted persons. And the point where the Constitution also makes the case for compensation for people who have been wrongfully arrested. We'll be right back. It looks like you have gotten a lot of comments this evening, and you've settled things that people were dealing with in their homes, and your answers are. So this one from Erisi, who is watching us this evening, is saying, I'm enjoying the conversation. These are basic things that you'd assume we all know, but we don't. And so thank you to your lawyer. This one from Akosia as well, watching us this evening. Akosia says, this has been very, very educative. There's so much we need to learn. We need to find time and abreast ourselves with the Constitution. There's so much in there that we don't know. Edward is also watching us this evening and says, I'm enjoying the conversation this evening. Most of your conversations are very, very technical. But tonight, it's so basic, and I'm following the conversation. Well, it's not my fault. Most of the issues we discuss are very technical on fact sheet, but I'm happy that tonight we've been able to break it down for you to have an appreciation of the issues we are dealing with. Let me read the last one. Amelia says that tonight's conversation is different. Most of the times, you are throwing technical jargons at us. But tonight, it's so basic and simple. I'm enjoying the conversation. Thank you to the lawyer as well. So I thought we would have a lot more time on our hands, but time is really fast spent. Let me ask this one, which is also in the Constitution. A person who is unlawfully arrested, restricted, or detained by any other person shall be entitled to compensation from that other person. What's the Constitution saying?
what it actually means is that when you have gone through the trial process and that you have been convicted, but then through an appeal process, your conviction is quashed, you have the right to go to the Supreme Court for compensation. In fact, it happens. There has been 1 or 2 instances that Xavier, the MP, took on that matter and then got compensation from the Supreme Court. But apart from the criminal aspect, what I've told you, there's also civil aspect of compensation. When somebody wrongfully accuses you, that results in prosecution. Whether the prosecution comes to the end or not, you have civil rights against the person. You can sue the person for damages for causing you that harm. Although we rarely use that, but I encourage people to use it because there are so many cases that I've handled that you realize from the onset that evidence was planted. People concocted evidence just to ensure that the person is embarrassed. There's a case that I did. The person was vying for a chief. In fact, because the opponent decided to concoct evidence and then get the police to charge him with defilement.
Wow.
Yes. He ended up losing his chieftaincy title because, chiefs, these kind of allegations are very serious. So at the end of the case, what has he gained? Nothing. He has lost his chieftaincy title just because of the mere persecution. So in that instance, although there hasn't been conviction, in fact, he was acquitted, although there hasn't been conviction, you can apply to the court in a civil action for wrongfully accusing you of such offenses. So you can get a lump sum as damages for doing that. But it's quite unfortunate that you cannot be reinstated to where you previously were. That's quite unfortunate.
Interesting, interesting. Well, we'll have to end it here. I'm grateful that Godfrey joined me.
There's a lot to discuss, but the time is limited.
The time is very, very limited. And I've even pulled you since morning. I've been here with you. And then this evening, we are here as well. Godfrey, I'm so grateful.
I'm also very grateful. And it's always a privilege to educate the public because there's a lot to learn, especially with our criminal justice system.
Indeed.
In the morning, I spoke about the case tracking system. I want people to test it.
Yeah.
And let's see whether it works.
Indeed, indeed. Well, for those of you who may be seeking to find out where Godfrey works and maybe make contact with him for further education or maybe to handle your cases, he's an associate with the Yabayama and Co. Afisem Chambers.
Efisem who matters.
Efisem Chambers.
Yes.
And a member of Crime Check Foundation. So you find him, Godfrey, and him, Nyakon, and have your conversations with him. But for me, I'm grateful for the rest of the team, back end, Amos, Kwame Damte, Neo Kanta, FCC, all of us. We are grateful to you for joining us tonight on Fact Sheet. Do have a pleasant evening.